Welcome to Professional Insights, brought to you by the National Referral Network and hosted today by me. This is where we share insights, professional wisdom, and a whole bunch of other stuff for the edification and prosperity of those who would watch this. And today I'm with Dave Brown. Dave is an attorney. I'm supposed to say you're not my attorney. You could be someday, but I hope not. And the reason I hope not is because Dave is a probate attorney. We talk with our clients a lot about the need to draft an estate plan to avoid probate. Today, Dave's going to talk about what probate actually entails, how long it takes, and oh Lord, what it costs. So, exactly Dave, thanks for giving us a couple minutes. Walk me through kind of what a typical probate looks like, just for a second. First of all, what is probate?
All right, so I'll speak about in the state of California because that's where I practice and that's where I'm licensed. But some of these generalities also hold true in other states, especially out west where things are codified or statutory. But the basic idea of a probate case is an individual has passed away. We talk usually about loved ones because it's usually a family member, but sometimes it's a next door neighbor. An individual has passed away, and for some reason, they have not left what I would call, or what attorneys would call, a proper estate plan, testamentary documentation. So there may be only a will, or there may be no will at all, or there may be a document that's handwritten with some instructions that have testamentary effect but aren't technically a will. And all of those instances would cause an individual to require a judge's order in order to deal with the assets and liabilities of an estate. That is converse to the idea of having a trust or entities that would allow an individual's assets and also liabilities to be dealt with without a judge order.
So in other words, the judge is now in the position, I was going to say unenviable position, of having to play traffic cop on all the assets and make sure that whoever is entitled to get whatever gets it. Is that more or less it?
Yes, that's exactly right. And there is a tension between the assets that will pass and distribute to beneficiaries. Usually we would use the word heirs, but not always. And creditors who are owed something out of the estate of the individual who has passed away. And so that's the beginning of the process right there.
So in other words, somebody passes away, everybody lines up to get paid, whether it's
the
beneficiaries, the heirs, the creditors. So even though so-and-so is no longer with us, the gardener still needs to get paid. The lights still need to stay on. So you need to pay the utility. Stuff still needs to happen.
Absolutely correct.
And especially, so I'm curious about this. So someone passes away, all that stuff still needs to happen.
Yeah.
How does it happen? The judge says, okay, probate lawyer, you hire people to make sure that the plants get watered. Okay. Or whatever. Is that your job?
Well, in a way, and that is the beginning of the complication. So the first thing that I talk about with a potential client when they're trying to figure out whether they need a probate is who has the authority to act on behalf of the individual who's passed away. It can be something as, I think, bizarre, but I understand the logic of it, of paying the mortgage for a parent's house. Mm-hmm. When the banks find out someone's passed away, they don't want to create a situation in which a third party might make a payment and then sue the bank or the beneficiary to try to get ownership. So the banks will routinely stop accepting any payment against a piece of real estate. If it goes on long enough untended or uncared for, then the bank will start to foreclose. And that can be a large asset or a small liability or a large liability, anything from the electric bill to a mortgage to a payment owed to a company.
Okay, so is it possible that someone passes away? There's plenty of money in the state. Maybe they have a large savings account or whatever. There's plenty of money there to pay the bills, but everything gets frozen because it's unknown who should be accessing those accounts and paying the bills. Is it possible that foreclosure could occur just because everything's been frozen for long enough?
Yeah, so there are two responses to your question. So let me answer them in two parts. Going back to the authority, the individual who has a right to must petition the court for special court authority called letters. If there's a will with an executor, they would be letters executor. If they're not, they would be called letters administrator. There are other facets of that, but that's the basic idea. With that special court order, that individual then has the authority to begin to settle debts, pay creditors, and then move towards a distribution. So in regard to the house situation, in my office, when we're dealing with somebody who has real estate, we are absolutely tail on fire about making sure that everything is moving towards making sure the bank has a status as well as the authority to receive payments and keep it settled. I think I've been a lawyer 26 years, going on 27. I've done more or less only probates for about 15. In that amount of time, we've only had 2 houses foreclosed. The majority of our clients deal with houses, but in those instances, the client walked in the door when the foreclosure paperwork was already tacked to the front. They were already literally days away. And, we did everything we could do. But there comes a moment where you can't undo that.
And are judges generally aware they have to generally be aware that bills need to get paid, mortgages, what have you. Someone needs to be able to access the money to do that, aren't they?
Well, yes, and there in probate court, there is, sorry, this light is bothering me. In probate court, there is a very limited emergency procedure where, with a great deal of effort and additional paperwork, you can walk into court on an emergency basis that might be a week or 2 weeks to get that special court order called letters. But, typically the judges will say to you in no uncertain terms, I'm literally quoting them, if there's not a chopped off arm or a body in a trunk, it's just money. They are very callous about the money aspect of this.
So let's talk about timelines for a second. I'm curious about this. So someone passes away on Wednesday. They don't have a will. They didn't do anything regarding estate planning. The estate is reasonably healthy as it relates to assets. They pass away on Wednesday. How long before a judge starts working and starts the wheels turning on the process?
Well, in the state of California, we still have an anachronism left over from the horse and buggy days, and this may be true in most states in America, but where I practice, we still have to publish in the back of a newspaper. This literally comes from the 1800s. We could do away with that in the internet world, and it will go away at some point, but that's still a statutory requirement in the state of California. So it takes my firm about a week, 10 days to put together the petition with all of the documentation. From the date that we file, let's say in Sacramento County, we're looking at about a 2-month first date to appear in court and receive that special court order called letters.
Let's stop there for a second. Okay, so you're saying someone passes away on, I don't know, Wednesday, October 10th.
Right.
You're saying on Wednesday, December 10th, 2 months later,
or longer in some instances. It's going to depend on judges' schedules and calendars.
So there's a lot that can happen in 2 months.
That's correct.
What happens during the 2-month period? Does it just grind to a halt?
It's a very difficult situation. What we counsel people to do is pay any bill that they either have the funds for or that the entity will accept money for.
So the heirs might have to come out of their personal accounts to keep the things. And now, are they allowed to pay themselves back?
Yes.
Once they get, okay, great. So at least
they are reimbursed for those expenditures. But now you can understand the point of stress on this for the attorney and for the client is, if you've got something that's really boiling over, if somebody walks in with a notice of foreclosure that's 3 weeks later, you got a real problem on your hands. That's not the usual situation.
So in other words, okay, so let's go down the road 2 months. Judge, here's the case, appoints Dave Brown as probate attorney, okay, because that's how it works. The first thing the judge is going to do is to appoint an attorney to run point on all this, okay? What is your job and what does it look like and how long does this take to finish itself? It's about 2 years, isn't it?
Not quite at this point. COVID affected some of this, but so let me give you just a couple details about that. The individual that the judge will appoint is someone called the personal representative, the executor, or the administrator, one of those titles, based on whether or not there's a will. So the attorney would file the petition and represent that individual. They are considered to be a fiduciary by the court. Now, that first hearing date happens about 2 months out. And at that moment in time, they receive a special court order called letters testamentary, letters executor, letters administer, etc. So from that moment in time, the fiduciary begins to marshal assets, which simply means to collect everything they can and try to identify all of the liabilities that may exist. From that moment forward, they can also access money and begin to pay down certain bills.
So in other words, it's your job to go, okay, I have to take inventory over
That's right.
not who's the beneficiary, who the creditors are. I have to
right.
get all of this assembled and then get the thing going. Okay.
That's exactly right. We start having creditors paid. We start identifying what distributions might go towards a beneficiary. But a lot of this cannot be done without judge oversight. So our responsibility also is to correctly assess what needs to come in front of a judge in the interim to get permission to pay, or we also deny certain creditor claims.
Okay.
Many times we have the situation, which I find to be strange, but a neighbor walks up and knocks on the door and says, to use your analogy, you mentioned this earlier, I've been mowing Jim's yard for the last 3 years. He owes me 90 grand. When are you going to pay me? And,
Right.
1% of the time it's true. And 99% of the time someone's trying to scam him.
Or, this is, I don't know, we're from Las Vegas and he made a trip here one weekend and he owes us 100 grand.
Right.
This menacing looking guy.
Incredible how
okay, so let's talk about cost for a minute, okay?
Yeah.
Typically, we tell clients that the cost of probate, soup to nuts, is about 6% of the estate's value. Is that more or less correct?
It's a little more difficult under California's statutory, meaning law. It's under California statutory pay. So there is a probate code that we refer to as 10,810, which identifies payment as 4% of the first 100,000 of the estate, 3% of the next 100,000,
okay,
2% of the next 800,000.
So it could be in that neighborhood, give or take.
Yeah, what I tell people, and this is based on experience, I know in my head, if you have a $500,000 estate, and it's a gross value, not a net value. So if you got a house, this is a very common number.
Right.
If you have a 500,000,
yeah, a house is worth $1 million.
Sure, all the time. If it's a $500,000 estate, the executor fee is about $17,000. The attorney's fee is about $17,000. You're looking at somewhere between 35 and 40 grand by law when you add the court costs and the publication. If it's $1 million, it's not twice as much, but it's about 70% of on top of that. So,
and Dave, I'm now going to give you the reason why there are so many lawyer jokes. The lawyers, the lawyers get paid first, right?
The executor and the attorney are paid exactly the same amount. Executor meaning the personal representative. Sure. We are paid exactly the same amount. We both have a lot of work to do. It's not made up, and that does come off the top of the estate. So that's codified in California.
Okay. So needless to say, this is a process that first of all, you've unbundled this very well for us, and we thank you.
Thank you.
As we start to wrap up here, this is certainly a process that everybody should seek to avoid if you, however, find yourself in the middle of it. As we discussed, it seems as though hiring or having a probate attorney at your disposal that knows what they're doing is pretty critical, because they can make mistakes too.
Well, I think it is a very difficult process that, unless you really work in some type of arena that you're familiar with this, even the language is very unique. So if I would tell my brother or my sister, you can't go through a probate without an attorney. It's
Without
just
an
too
attorney.
complicated.
Gotcha. Listen, really appreciate it. For those of you that want to check out the National Referral Network, you can do so just by logging on to nrnamerica.com and checking out how that works. Dave, you are a newly minted member of the network. How do you feel like, just real quick, how do you feel like an association with many other professionals to solve other problems benefits your business?
Well, I think it's a wonderful resource because when we're talking about probate, and again,
Yeah.
as we mentioned first, you're in a probate situation because you don't have a trust or an entity. So
Right.
everything that you're dealing with at that point is kind of it's moving fast and it's hard hitting. There's a lot of things at stake. So having the ability to know that there are vetted professionals that others know and rely upon at your fingertips, at your disposal. Sometimes these things have to be dealt with in a 24-hour period. So
Okay.
that's an enormous benefit to me and my law firm.
So being able to link arms with the right
That's
professionals
right.
means a lot. And that's what we always
Yeah.
say. Well, if you're watching this and you don't know about nrnamerica.com or the National Referral Network, check it out. There's information there on how to become a member. Membership is free. We work with members to help them make the most of the network. You can reach out to us and ask us what that entails. And other than that, Dave, we thank you for your time here. And we'll be back next week, folks, with more professional insights.
Thank you. Have a wonderful day.